Welcome to our program. So good to have you. So good afternoon, everybody. And here we are. It's time to get your you-know-what together with Samantha Fitzgerald, and I'm Bianca Moreras, your host. And today our topic is on beneficiary designations, and it is a hot, chock full of information topic. So let me introduce to you Samantha. Samantha is an attorney in Plantation, and her firm concentrates 100% on estate planning and probate trust administration, and she is practicing for over 20 years. She's a CPA and has her LLM in tax. Welcome, Samantha.
Thank you, Bianca, for that beautiful introduction. I'm happy to be here. Welcome, Virginia. Right now, you're our only participant, but we have some other people registered, so hopefully they'll pop in when they have a second. But we're glad you're here. We can't quite see your face. I don't know if you want to move your camera up a little bit. We see your mouth.
For sure.
There you are.
Much better. And
perfect.
I'm Bianca Moreras. I am your host and moderator. I have a business development and career transition consulting and coaching business, and I bring 37 plus years of experience to the table, concentrating in law firms, working with attorneys and their firms to give them the ability to move their business to the next level. So that's us, and here we go. So Samantha, can you tell us a little bit about what is a beneficiary designation?
So a beneficiary designation is where you name a person or something else, as we'll talk about probably later on a particular asset. And when you die, that asset passes to the designated person.
Okay, so why is it important to have a designated beneficiary?
So without designating a beneficiary on an asset, the asset upon your death may have to go through, and probably will go through, a court-administered probate administration, unless the account or the asset is jointly owned with another person who survives you. And the way that the asset is titled is a joint ownership with a right of survivorship, because there are different types of joint ownerships where sometimes you just own your piece jointly with another person, but upon your death, you still own your piece, and it still passes through a probate administration onto your heirs or beneficiaries. So usually if there's no other joint owner, if there's no beneficiary designation, the asset will pass through a probate administration.
Okay, well, we don't want that to happen. That's why we're coming to see you. So what kind of assets can be designated, on a beneficiary?
So mostly we're just talking about financial accounts, which would include life insurance policies, annuity policies, retirement accounts, whether that be an IRA, a 401k, some other civil servant type of retirement account, regular bank accounts, most brokerage accounts, and those types of things. Even like sometimes people still have savings bonds. You might not be able to name beneficiaries on there. I'm not 100% sure. You can have joint ownership of those. I think you can name a beneficiary on them. I think it's one or the other. I think you can either have, so you can have two names total. So they can be jointly owned, or you can have them owned by an individual with a beneficiary designation. Pretty sure that's the rule.
Okay. So, yeah. Those savings bonds, hardly anybody uses them anymore, though. Yeah. Very interesting.
They're hard to buy even.
Yeah. Oh my gosh. Complication. What asset can't be designated to a beneficiary?
So mostly everything else. So like real estate, you cannot designate a beneficiary on any sort of real estate. Entities such as corporations and limited liability companies, you cannot designate a beneficiary on. Cars, boats, usually safe deposit boxes, just about anything other than a traditional financial account. Money, some sort of money or stocks, bonds, something like that. You can. Everything else, for the most part, you can't.
Okay. So, I heard about, that we should make our accounts POD. What does that mean?
So POD means payable on death. That is the synonymous for beneficiary designation. Same exact thing.
So then what does a TOD mean?
Transfer on death. And effectively, it's the same thing, but transfer on death relates to brokerage types of accounts, stocks and bonds, mutual funds, and that sort of thing, because they technically don't pay you the stock or the mutual fund, they transfer it. Whereas with a regular cash bank account, they pay you the money. So it's POD, TOD, payable on death, transfer on death, basically the same exact thing, different type of account.
Well, that makes sense. Thanks so much for clearing that up. I was slightly confused. Okay. So does my checking account need a beneficiary designation?
Absolutely. It's no different than any other account. It is a regular financial account. If you die, there's no other co-owner on the account, and you do not have a beneficiary designated on your checking account, even if there is $1 in the account, it will need to go through probate in order to transfer it.
Oh my gosh. But why don't they tell you in the banks that you should do that?
That's a great question, Miss Bianca.
It's just a good question, but they don't tell you that. That's terrible. Oh my gosh. I'm exhausted already. Okay. How do I designate a beneficiary?
So it's a little different depending on what the account is. So with a regular bank account, like a Chase, a Bank of America, a TD Bank, something like that, typically you have to physically go into the bank, sit down with somebody and update your forms, your beneficiary forms at the bank. To my knowledge, there are no banks that have moved into this century doing anything online. A brokerage account like an Ameritrade, a Fidelity, something like that, that you kind of manage yourself, you can typically log in and do that online. If you have a financial advisor at a Merrill Lynch or something like that, or an independent financial advisor that's managing your accounts, just tell them. They will prepare the paperwork and have you sign it. Life insurance, annuities, you typically have to contact the company, whether it be Northwestern Mutual or MetLife or something like that, and tell them what you want, and they typically will mail you forms, or sometimes they'll direct you to their website where you can get the forms, and then you fill them out and follow whatever procedures they have to get them back to them.
Okay, so that makes sense. What happens to an asset with a beneficiary designation when I die?
So when you die, this is important for people to understand. We just had this, real life issue. Let's say a POD bank account. So there's cash in an account. We just had an instance recently where the children of this woman, she died, and they said, okay, we're on the account as a beneficiary. It's a POD account. We had to do a probate for a different asset, but we all discussed and said, okay, well, that account is not part of the probate. That just passes to you directly. And then a few weeks went by, and they were very surprised to find out they could not continue to use the account to pay mom's bills. Well, when mom dies, the account is closed. It's frozen. It's done because the account owner is deceased. It is then paid to the beneficiaries. It's closed, and they cut checks to the beneficiaries. Or if it's a brokerage account, it's closed, and they're transferring those securities over to the named beneficiaries. The account is no more. You cannot continue to use the account. You can't deposit money into the account. You can't withdraw money from the account. You can't pay bills out of the account. The account is done, and it's paid out to the designated beneficiaries.
Oh, well, that sounds like it could be a problem right away. Oh my goodness. Well, okay. So what happens if my designated beneficiary predeceases me?
It's as if you do not have a beneficiary at all.
Okay.
So if you only have one designated beneficiary and they predecease you, then that asset, that account, will revert back and go through your estate through a probate administration. If you have alternate beneficiaries named, which you should, so you have 1, 2, and 3, first person predeceases you, then it's going to be paid to the second designated person. Sometimes you have multiple people in the first position. So you say, equal shares to 4 different people. So if one of them predeceases you, then it will depend on the particular beneficiary designation form, what happens. So you have to read the form. They're all different. There's no one size fits all. On the form, it will say, does that share then get divided equally between the remaining designated beneficiaries, which is usually the most common, or does that deceased beneficiary share go to their children? That can happen, although it's less common. It's usually one of those two. It does not matter what your will says, or if you have a trust, it doesn't matter what your trust says. They do not control these beneficiary designated accounts.
So you bring up a great point. So you can actually have a trust and you can actually have designated beneficiaries on other things.
Yes. So for instance, you may have a checking account with Bob as your designated beneficiary. And in your trust, you may have Sally as the beneficiary of the trust. But that account is going to Bob because the account is controlled by the designated beneficiary. The trust only controls assets or counts, property that's actually in the trust. So for instance, you may have your account. Some people say that the account, the designated beneficiary overrides the will or the trust. It's not really true. That's what it seems like. It's just not true because they all kind of drive in their own lane. The beneficiary designation drives in this lane. The will drives in the probate lane. The trust drives in the trust lane. And they each control their own little lane and nothing outside of their lane. They can't cross over lanes. So if you had an account that named Bob and Bob died before you, now you have no beneficiary. The other documents don't control that particular account. Now that account will end up going through probate. So if you have a will, then it will pass according to your will, which may not be what you want, but that's what's going to happen. So alternate beneficiaries are really, really important. If you're going to the trouble to name a beneficiary on an account, you should have a backup.
Okay, that makes sense. Thank you for that clarification. So here's something crazy. What if my beneficiary survives me by 1 day after my death?
They get it. They can even survive you by 1 minute. So in Florida, we don't have any sort of time period that a beneficiary needs to survive you by. So if you were in a common accident even, and you can tell who survived, that asset or account will pass to the survivor, and then the survivor owns the money. So it's going to pass then to whoever their beneficiaries or heirs are. They wouldn't have, obviously there's no beneficiary at that point named on that particular account. So it would go to that person's estate because they're dead. And then whoever their heirs or beneficiaries are is where the money will go. So that can be problematic in any circumstances. We've had, discussions with clients where they want to leave their spouse the money, but it might be a second marriage. So they don't want to leave the children of their spouse who aren't their children the money. And a couple could easily be in a common accident, a car accident or something, where they die. If somebody is still breathing when the paramedics arrive, they've survived, so the death certificates are going to reflect that. So, that's a very real concern for people. It could even be longer than a day, it might be 30 days, might be 45 days where the person didn't really get any opportunity to use the money, but then they die. Then the money is passing to their family or their beneficiaries.
So while we're still on that subject, is there a safeguard to that? Is it better to have a trust or something else than a beneficiary designated?
Yes, I'm a big fan of naming a trust as beneficiary on your accounts as opposed to people for lots of reasons. That being one of them, you have a lot more control over what happens. So in our trust documents, we typically say that somebody has to survive you by 60 days in order to inherit anything. So it's not a super long time, but it's obviously more than a day. So somebody has to at least survive by 2 months in order to take the money. But there's lots of more safeguards you can build into the trust. Maybe we don't even have a distribution to that person. We might continue to hold their share in trust for their benefit. So they still get to use the money however is needed or however is written in the trust. But then upon their death, so if they die 6 months later, 1 year later, and there's still a balance in their share, then it will pass according to the terms of your own trust, maybe back to your children or to somebody else. So that's a common thing we do when for our clients who still have their parents alive and their parents may need some financial support at some point. We put some money into a trust for the parents, can be utilized for the parents as needed, but when the parents pass away, then it goes back to our clients' children. So the parents are protected, but it doesn't end up going to other children of the parents, which would be our clients' siblings, or who knows where, maybe the parent gets remarried and then the spouse takes it and, it totally goes to a place that was not anticipated. So a trust is a really great tool for protecting money and making sure that it goes where you want it to go, while at the same time benefiting the people that you want to benefit.
Awesome. Oh my gosh, that's so much information. So I have a question in our chat, and their question is, if in fact you have, let's say, life insurance and it already has a designated beneficiary, if you create a trust, can that be changed?
Absolutely. You can always change your beneficiary designations while you are not incapacitated and still alive. So obviously, once you are incapacitated, you can no longer change any beneficiary designations unless you've given somebody a power of attorney and given them the power to change your designated beneficiaries, which is one reason why you might give that power. But as long as you're alive and you have your capacity, you can change your beneficiary designations at any time.
Very good. Yes. So just by everything I learned today, Samantha, which was a lot, I guess a trust is the way to go and be protected all the way across the board instead of piecemeal, which, like a password, you might forget what password you put on what property, right?
Absolutely. You'd be surprised. People, they open an account, they designate a beneficiary, they completely forget, set it and forget it, right? They completely forget what they have there, and years and years and years go by. I've seen the wrong people inherit accounts. It can be a very tragic situation. There are some safeguards in our statutes now, like in the event of a divorce and things like that, that some people are automatically cut out. But bad things can happen. Lots of times people, when they have children, they end up naming their minor kids as they name their spouse and then they name their minor kids as beneficiaries on life insurance and retirement accounts and stuff like that. You don't want anything passing to a minor child because then you're going to have a court supervised guardianship, which is the PITS. So people do things without, when they don't have a trust. But once you have a trust, it is a fantastic tool. Absolutely name it as a beneficiary on accounts. It provides lots of safeguards. It provides creditor protection to those beneficiaries, protection from their spouses, disability, incapacity, substance abuse, in addition to, an untimely death, and then your money going where it's not supposed to go. So a trust is a fantastic tool for lots of things, in addition to probate avoidance.
Wow. So I don't mean to backpedal here, but we do have some time. We talked about a POD. We talked about a TOD. What about FOB or FB for the benefit of? I guess it's an FBO, because I know there are some accounts where you can say that it's for the benefit of someone. I actually have an account like that, which is an
Really?
investment account. And it does name my children as, and it says for the benefit of, and their names. So
I've never seen that. I'd be interested in seeing that. That's interesting. Oh, maybe, did you open the accounts for your kids when they were young?
no, they're my accounts. They're actually my investment accounts. And then I put for the benefit of their names. So at least I was told it would pass to them, God forbid. But now I'm nervous about that. That's why we're going to do a trust, Samantha.
Yeah, that's interesting. I've never seen for the benefit of. I've seen ITF in trust for. Maybe it's kind of similar to that. It's, you don't really see them anymore. They're very old designations. So maybe it just depends on the financial institution, but effectively all those things are the same, just in a different format, but it means the same exact thing, where it is passed to the beneficiary upon your death. However it gets there, it's passed directly to the beneficiary.
Perfect. Okay. A little scary, but perfect. Well,
Which you wouldn't want, if they're, when you die, if they have a judgment filed against them, or if they are incapacitated or disabled and receiving some sort of government benefits, or they're in the middle of a bankruptcy. I see that somewhat often, where an adult child is filing bankruptcy, the parent dies, and bam, they're inheriting assets. Bad timing.
Bad timing, bad timing. Yeah, I think, even though these are all good things to do in lieu of nothing,
right?
The trust is really the way to go. So I'm so glad that you're so knowledgeable about that. So I'm going to thank Samantha for all her information. This is so valuable. There's no better place than to come to these programs and learn something new every single month. And so we will be here next month on Thursday, because of Thanksgiving. And we will actually be here on the 18th of November instead of the 19th. So mark your calendars. We'll send out our invite, and we really look forward to seeing you. Thank you, Samantha. Have an awesome day.
Thanks, Bianca. Thanks for coming, Virginia. Have
Thank
a
you.
great weekend, everyone.
Bye-bye. Take care.